Two original action cases I want to mention more briefly. These are cases which were both argued January 8th. This was original action water day in the Supreme Court of the United States, just about a month ago, exactly. Two cases that day. Common theme of the cases, the role of the United States in these sort of water allocation distribution in original cases. One involving the Bureau of Reclamation, the other involving the Army Corps of Engineers. The first case is the Texas v. New Mexico case. It involves the Butte Dam reservoir. You can see it right there. In this case, this is basically Texas's complaint. Texas saying, Mexico, you have violated the compact we all agreed to, because you've been allowing your residents south of this reservoir to divert a lot of groundwater, which is hydrologically connected to that reservoir. And they've been decreasing the amount of water coming down to Texas and country of Mexico. The result is less water for us. You can't permit more diversions than existed in 1939 when we entered into this compact. That's their complaint. The United States made a motion to intervene in the case. And the U.S. said, look, we have to administer this reservoir under the Bureau of Reclamation, and it's affecting the amount of water, and we have international treaty responsibilities to make sure a certain amount of water goes to Mexico. So we should be a party in the case. But they're not a signatory to the 39 Compact, which is between the states, and not between the states and the United States. The case is argued in January, about a month ago, in the Supreme Court. That's Ann O'Connell from the Solicitor General's office. The only thing they really talked about was the role of the United States. They've not yet really gotten to the merits of the case in the Supreme Court, or not. And the argument basically was on whether the U.S. could intervene or not. It kind of looked like the U.S. probably won't be allowed to intervene, but we'll see. They'll probably be allowed to file as an amicus and not intervene. The other case is a really interesting case. This is Florida v. Georgia. What the reason this is so interesting is original action, right, equitable apportionment cases, historically, were out west. They were never in the east. But now they're in the east. There's a whole series of cases in the east. Water scarcity has come to the east coast of the United States. It used to just be a western issue. It's now an eastern issue as well. In this case, you involve what's called, I will call it, because it's easier to say, the ACF basin. There, you can see, Georgia, Florida, among others, are fighting over this water basin. And here's Florida's complaint. They want equitable apportionment to cap what Georgia takes from that basin at 1992 levels. They're saying you acted in bad faith for a bunch of years, you've increased your water use, you're reducing the amount of water coming down to Florida. And it's hurting our ecology and our fisheries by decreasing the amount of water. The special master in this case, Ralph Lancaster, who's been more special master often than anybody else, I think, historically, in his equitable cases, he recommends denying Florida's relief. Because they say, you did not prove by a clear and convincing evidence that capping Georgia's use would actually redress your harm. But he doesn't say that there's not harm. We say you're being harmed, but you haven't shown by sufficient standard of proof that it would actually make a difference. And the reason you haven't shown it is, it's the Army Corps of Engineers that administers this whole water issue, not Georgia. And it's not clear what the United States would do if Georgia did less. The United States might not let more water go into Florida, because the Army Corps of Engineers decide how much water of what's there goes down below. The United States might or might not do it. And the U.S. is not a party to this litigation. That goes before the United States Supreme Court. Greg Garr argues the case from Latham Watkins for the state of Florida. And reading the tea leaves from the argument in this case, I think Florida has a good chance of prevailing and beating back the special master's recommendation. Justice Kagan sort of saying, you've got common sense on your side. If Georgia uses less water, then there's more water available the Army Corps of Engineers could send down, whether they do or not, but it just makes sense. Sotomayor is the same. You have to prove it was, you have to show the exact amount, just that there'd be more. And even the Chief Justice said, you can't see it, he said, this kind of reminds me of a bidding discrimination case. You don't make them show that actually they would have gotten the contract if they hadn't had bidding discrimination, just they would have had a shot at getting the contract. Here, you have a better shot. The Corps could do something about it. So if I have to guess, I think here they said, Greek granting Florida greater claims, let's change the facts of the ground according to the Corps. It might have caused them to adjust what they sent down